Speaker, there's no need for me, as I said, to be extended here past our lunchtime. But I rise to support the bill entitled the Money Services Business Amendment Bill 2019. And as intimated by my colleague and member from St. Christopher 4, these amendments, Mr. Speaker, attempt to modify the existing legislation to wit the Money Services Business Act, Cap 21.21. Mr. Speaker, one may ask, what is a money services business? And interestingly, I went to the U.S. Treasury website to find the definition provided by FinCEN, the Financial Crimes Enforcement Network, FinCEN, which is an arm of the U.S. Treasury and a branch of the U.S. government. And we in St. Kitts have become quite familiar with FinCEN, as everyone will recall that there still exists a FinCEN advisory citing, unfortunately, the Douglas Labor Administration as, my words, harboring, I'm paraphrasing here, Mr. Speaker, harboring illicit actors. And as I said, unfortunate, Mr. Speaker, because government is continuous. So we have inherited that cloud under the advisory. And the member from number 9, Nevis 9, did make a statement in terms of our current disposition as it relates to lifting that advisory. Mr. Speaker, the FinCEN definition states that the term money services business includes any person doing business, whether or not on a regular basis, or as an organized business concern in one or more of the following capacities: currency dealer or exchanger, check cashier, issuer of travelers checks or sellers as well of travelers checks, redeemer of check, money orders and so on, and money transmitters and postal services, Mr. Speaker. And we do all of the above here in St. Kitts and Nevis. Mr. Speaker, each money services business is a financial institution, and as such needs to be licensed and regulated. And that has been done over the years, as can be gleaned from the Money Services Business Act I alluded to earlier. So these amendments, Mr. Speaker, I also earlier intimated, attempt to modify and indeed strengthen the existing legislation by providing clarification on the licensing of these financial institutions or money services businesses. I need not read the amendments, Mr. Speaker, because my colleague member from number 4 did so adequately. except to add and reinforce the fact, Mr. Speaker, as it relates to the amendment of Section 2, Mr. Speaker, which attempts to insert or will insert immediately after the definition of license the following new definition, Mr. Speaker, and I quote, microfinancing and lending means a short-term financial facility in the form of a business or personal loan not exceeding $50,000 made to individuals or entities without collateral. And I want to make the point here, Mr. Speaker, because I have been advised as it relates to individuals, there is a policy cap that individuals cannot access more than 5,000 EC dollars at any one period or any one time, Mr. Speaker. Section 2, in reference to its amendment, speaks at B here, and I quote, replacing in subparagraph 5 of the definition of money services business, the expression payday advances with the expression microfinancing and lending, Mr. Speaker. So, Mr. Speaker, it is very clear that the importance, it is very clear, Mr. Speaker, I should rather say, and it's very important as well to strengthen subparagraph 5 of the definition by replacing the expression payday advances with the expression microfinancing and lending. These financial institutions, Mr. Speaker, or money services businesses, they satisfy a void. They fill a gap in the market, as some of our people cannot access what I call the established banking institutions. Although we always implore that they ought to be cautious in terms of the advances they require, or the advances they try to procure, Mr. Speaker. But we must agree that some of our own people needs to fill that gap at some period or some time in their lives, unforeseen circumstances. It also expands payroll advances, Mr. Speaker, to be able to lend to small businesses. I saw a contractor in the gallery earlier who may want to finance his payroll, perhaps for one weekend. His employer may not have paid the claim. So on that basis, he or she can approach the lending institution and have an advance on their payroll at a particular time. But Mr. Speaker, the member from number 4 and my colleague, he was clear and he was concise. So there's no need for me to say much more, Mr. Speaker, except again to add that we are, in fact, as he mentioned, the amendment of Schedule 5. Here was Section 15 of the bill, Mr. Speaker. And the requirement, this capital and statutory deposit requirement, and the different classes. We know that there are classes in terms of the different I don't want to call any particular institution, but those who transmit money to and receive monies from far and near, Mr. Speaker. So, Mr. Speaker, these loans as well are not collateralized. So we believe that the requirement to have the minimum capital required as stipulated here, $50,000, and the statutory deposit in some cases are important. Mr. Speaker, and I know this capital requirement has been paid into the SRC. And Mr. Speaker, I believe, as I said, it's not a controversial bill. So I won't tarry long, except to say, Mr. Speaker, I commend this bill to safe passage in this honorable House. I thank you. May it please you, sir.